Back to structure again, Attorney General Gonzales. I assume that we can agree with the proposition that in the enforcement of the laws, the Department of Justice should be independent.
Yes, sir.
Can we also agree that one of the institutions of government that the Department of Justice needs to be independent from in the enforcement of the laws is the White House?
No question about it, Senator. If you're talking about prosecuting someone in the White House, yes, we should be independent from them when making those kind of decisions.
And indeed, over a long history, there have been concerns about influence from the White House to the Department of Justice, and people, indeed, members of this committee, have expressed concern about the White House Justice connection over many years. Is that not also correct?
I think that's a legitimate concern. I think it's very important. I think it's one of the reasons, for example, that Attorney General Ashcroft recused himself in connection with the Plame investigation.
The documents that I have given you are two letters. One is from Attorney General Reno to Lloyd Cutler, the special counsel to the President, dated September 29th, 1994. It lays out the policy for contacts between the White House and the Department of Justice in the Clinton administration. And to give credit where credit is due, it's my understanding that the distinguished Senator Hatch, who was then the chairman of this committee, had substantial interest in this and viewed it as a significant area of oversight, and I want to commend him for that. And what it does, the language is behind me. It says that with regard to initial contacts involving criminal or civil matters, they should only involve the White House counsel or deputy counsel, or the president or vice president, and the attorney general or deputy or associate attorney general, period. The more recent memorandum, the other document that you have in front of you, is from April 15th, 2002. It represents the policy of the Bush administration regarding White House Department of Justice contacts. And there in the highlighted part on the front, it says that these contacts regarding pending criminal investigations and criminal cases should take place only between the office of the Deputy Attorney General and the office of the counsel to the President. And then if you flip back to the very last page, there's sort of an exemption paragraph that exempts further the President, the Vice President, the counsel to the President, national security and homeland security officials, staff members of the Office of the Attorney General, if so designated, and staff of the Office of the President, the Office of the Vice President, the Office of the Counsel to the President, the National Security Council, and the Office of Homeland Security. So I asked my staff to take a look at what the difference was between those two in effect, and if you could, this is in effect during the previous administration. This was the Clinton protocol. And there were four people, the President, the Vice President, Deputy White House Counsel, and the White House Counsel, who could participate in these kind of discussions about cases and matters and initiate them with the Department of Justice. And on the Department of Justice side, the only people who were qualified to engage in those discussions were the Attorney General, the Deputy Attorney General, and the Associate Attorney General. So they had narrowed very carefully the field of people who could have these discussions, which I think is a very important safeguard. To narrow that portal, to police it, it's almost like there's an airlock there for those communications. Now, here's the result that I asked my staff to put together if you count all the people who are eligible under the new program. That, to me, your staff can check on exactly how accurately we've done it, but there are, I want to say what were the numbers? 417 folks in the White House who are eligible to have these contacts, and about 30 some in the Department of Justice. And again, from a structural point of view, my question to you is, when over years this issue of White House to Department of Justice contacts has become so significant, when, you know, even on the Republican side of the Judiciary Committee, there's intense concern about this over the years, and it's been narrowed down to a fine porthole like this. You were the White House counsel at the time. What possible interest in the administration of justice is there to kick the portal so wide open that this many people now can engage directly about criminal cases and matters compared to before?
Senator, I think you've raised a good point here. One that I was concerned about it at the counsel's office, and I remain concerned as Attorney General, is in terms of making sure the communication between the White House and the Department of Justice remain in the appropriate channels. That I do recall being concerned about that as White House counsel.
Quite a pronounced change, isn't it?
Well, it is a pronounced change. However, that it's my understanding of the policy. Again, this is DOJ policy that occurred April 15, 2002, was that communications with respect to individuals at the National Security Council would not be with respect to particular cases, but with respect to...
This is national security aside. That's a proviso in it. This is not national security. This is criminal cases and civil cases, initial contacts between the White House and the Department of Justice.
Senator, let me say this. I'm not aware that there are initial contacts between the White House and the Department of Justice as an initial matter with respect to specific criminal cases, or if there are, let me put it this way, I don't think there should be. I think it's very, very important. I agree with you. It is important to try to limit the communications about specific criminal cases between the counsel's office and the Department of Justice.
But when I see the rules open this much, it makes me wonder to what extent this safeguard is considered significant in this administration. And then we hear stories like we've heard of United States Attorney McKay reporting that when he went to the White House to be interviewed, he was told by White House counsel Harriet Miers that he had, and this is the word he used in quotes, mishandled the voter fraud investigation in the recent election. Now, I've met Harriet Miers. She strikes me as a very careful, intelligent, thoughtful lawyer. She wouldn't throw around a word like mishandled, I don't think, which implies a very significant degree of evaluation. And it seems to me that one of two things is true about that conversation. Either she had no idea what she was talking about, and she misused that term, or she had some idea of what the evidence was in the voter fraud case in McKay's district that did not go forward. And what I'd like to know is, do you know which one it was? And if it was the latter, how on earth did she get evidence regarding a Department of Justice case sufficient to form the professional opinion that the United States Attorney had mishandled that case?
Sir, I am not familiar with the conversation that occurred between Mr. McKay and Ms. Myers. I like you, I'm aware of the reports, but sometimes...
Didn't that send up a big red flag?
Sometimes stories are wrong, and the fact that she also may have been aware of the reports, knowing that this was an issue in this district, that she may have inquired about, well, what happened here? Is there something to worry about without having any specific knowledge about the underlying facts of the case? But I don't know. I'm just...
Has there been any effort to run down what happened that caused a White House counsel to reach an evaluative opinion about an ongoing prosecution, or even then a closed prosecution, I gather, just by way of safeguarding how information is traveling back and forth across this now wide open screen?
Well, I think the safeguards that you're referring to, I think, are very, very important. I'm not sure that there would have been a prosecution relating to the absence of a prosecution. Well, to answer your question, I'm not aware of any going back and looking at what happened